Hello everyone, myself Brunda. I am studying at Sri Venkateshwara College of Engineering in 5th sem from the course Research Methodology and Intellectual Property Rights. Let me look over about protection term for industrial design. Let me look over contents, introduction, policy of industrial design protection, term of protection of industrial design, object ineligible for protection as industrial designs, conditions for protection of industrial design, and scope of protection of industrial design. Let me look over about the introduction. Industrial design protection means that a competent state agency grants an industrial design patent to an organization or individual that submits an application for registration and industrial design that satisfies the condition for protection according to the provisions of law. Industrial design protection is provided for a shape, configuration, surface, pattern, color or line or a combination of these which when applied to a functional article produces or increases aesthetics and improve the visual appearance of the design, be it a two-dimensional or a three-dimensional article. As per Indian law, under the Design Act of 2000, industrial design protection is a type of intellectual property right that gives the exclusive right to make, sell, and use articles that embody the protected design to selected people only. Protection rights are provided for a period of 10 years. They can then be renewed once for an additional period of 5 years. Design protection provides geographical rights like patents and trademarks do. To obtain design protection in India, the same has to be registered in India. The prerequisite for design to qualify for protection are as follows. It should be novel and original. It should be applicable to a functional article. It should be visible on a finished article. It should be non-obvious. There should be no prior publication or disclosure of the design. Let me look over about the policy of industrial design protection. Like most other objects of industrial property rights, the right to an industrial design will be established on the basis of a decision on granting a protection title by competent state agency according to the registration procedures which specified in the law on intellectual property or an international treaty which victim is a contracting party. Industrial design protection title means a document issued by a competent state agency to an organization or individual in order to establish industrial property rights to an industrial design. The industrial design protection title is called the industrial design patent. Let me look over about the term of protection of industrial design. According to the provisions of Clause 4, Article 93 of the Intellectual Property Law, an industrial design patent takes effect from the date of grant and lasts until the end of 5 years from the date of filling the application. Let me look over about the objects ineligible for protection as industrial designs. According to the Article 64 of the Intellectual Property Law, the following objects are not protected in the name of industrial designs. Outward appearance of product which is necessarily due to the technical features of the product, outward appearance of civil or industrial construction works, shape of a product which is invisible during the use of product. Let me look over about conditions for protection of industrial design. Be novel. An industrial design shall be deemed to be new if it significantly differs from other industrial designs which have been publicly disclosed by use or by means of written descriptions or in any other from either side or outside witness prior to the filling date or the priority date as applicable of the applications for registration of the industrial design. Two industrial designs shall not be deemed to be significantly different from each other if they are only different in features of appearance which are not easily noticeable and memorable and which cannot be used to distinguish such industrial designs overall. An industrial design shall be deemed not yet publicly disclosed if it is known to only a limit number of persons who are obliged to keep it secret. An industrial design shall be deemed not to have lost its novelty if it published in the following cases, provided that an application for registration of the industrial design is filled within 6 months from the date of publication. It is published by another person without permission from the person having the right to register it. It is published in the form of a scientific presentation by the person having the right to register it. It is displayed at the National Exhibition of Victim or in an official or officially recognized international exhibition by the person having the right to register it. Be of a creative nature. An industrial design shall be deemed to be creative if, based on the industrial designs already publicly disclosed through use or by means of written descriptions or in any other form, either inside or outside Vietnam before the filling date or the priority date, as applicable of the application for registration of the industrial design. The industrial design cannot be easily created by a people with average knowledge in the heart. In the following cases, the industrial design started in the registration application is considered non-creative. An industrial design is a simple combination of noun design features, publicly disclosed design features that are simply put together, such as replacing, changing location, increasing or decreasing quantity, etc. Industrial design is a shape that copies or imitates part or all of the inherent natural shapes of trees, fruits, animals, shape of geometric shapes, circle, triangle, square, rectangle, regular polygons, etc., are widely known. An industrial design is a simply reproduction of the shape of products or works that are well known in Vietnam or in the world. An industrial design that imitates an industrial design in another field if such imitation is already widely known in reality. For example, toys that simulate cars, motorbikes, etc. Be susceptible of industrial application. An industrial design shall be deemed to be susceptible of industrial application if it can be used as a model for mass manufacture of product with the outward appearance embodying such individual industrial design by industrial or handicraft method. In the following cases, the object started in an industrial design registration application is considered incapable of industrial application. It is in the shape of product whose state of existence is not fixed. Products in the gaseous state, liquid form, etc. It can only be produced by special skills or cannot be repeatedly produced in the same shape as the object started in the application. Scope of protection of industrial design. Requirements on the scope of protection in the industrial design description. The applicant must list all necessary and sufficient design features to determine the nature of the industrial design and the scope of industrial property right for an industrial design shown on photos or drawings started in the application, including new design features that are different from non-similar industrial designs. Thank you.